the website. I'm trying to do it once every week. Now, I've been very busy with work, so yes, I will try to answer the questions. Anyone coming live now, you can ask your questions. I'll try to answer them to the best of my ability. So the first question from Ruth 4470. I overstayed by 1 year. So she is overstayed in the UK by 1 year, a few months, and I left 2020 voluntarily. Can I go back on skilled worker visa with a job offer? Yes. So in 2020, so it's more than 12 months you left voluntarily out of the UK. You may have gone at your own expense. So you should be able to file any other UK visa application provided you meet all the eligibility requirements. For example, if you're applying for a skilled worker visa with a job offer, you have a CAS, etc., cost and all. Make sure that everything is genuine. They will test anyone who has overstayed in the UK. They will be careful. They will make sure that everything is genuine, the job is genuine. There is no skilled worker selling as such that happens, no frauds or anything. You can file any UK visa application since it's more than 12 months you have left the UK. Okay, next question on the channel. Thank you for this. Is it true that the increase of the IHS fees will start only after January 31st at the earliest? Yeah, so the NHS immigration health surcharge, which was due to increase probably after 16th of Jan, it has been postponed and it will definitely be increasing. There are still discussions going on. I don't think the government has given up yet. So January 31st is the earliest when it will change, not before that. So and there are other videos that I have made how to save NHS surcharge or how to file it earlier, delay things, etc. etc. Spouse visa, skilled worker, student, any visas for that matter, whichever has immigration health surcharge. So yes, watch those videos. You may be able to save some IHS fees since the date of increase has been postponed now. So it will only increase after 31st of January at some point. We still don't know the point yet. Okay, next question. I'm already in the UK. If I need to take sponsorship from restaurant, I need to give English test or only interview though. So Rajendra. So the question is, you are already in the UK. If you need to take sponsorship, so what you mean by sponsorship would be a skilled worker visa from a restaurant. I need to give English test. Yes, you will have to pass the English test at level B1 in all the four components: speaking, reading, listening, writing, all four of them. And B1 level only interview. I don't know what you mean by interview. You may have to interview through to your employer to get a job, to find the job, but I don't think Home Office interviews you. If the employer is happy to sponsor you and is happy with you, then they may be able to give you the costs and you can file the skilled worker visa, provided you have some valid leave. You said that you are in the UK, so if you're on a visitor, you may not be able to switch, but in any other leave, you may be able to switch, most probably. So next, Sujit Pal, next question. So I see many people joining live. If you all have any live comments, you can ask them now. I'm trying to answer the questions on the channel. So, hi sir, unfortunately my wife passed away. I'm thinking of remarriage. So my scheme became very honest right now. You can send you will make fees how much and I have to show the spouse in the UK. Okay, so Jitpal, so your question is about spouse visa financial requirement. You are on universal credit, so I'm not sure whether you will be able to sponsor if you are getting benefits. Universal credit is not one of the eligible benefits where you can sponsor without income. So unless you are getting any of those, there is a list of benefits. If you Google search for, I'm not sure whether it is on our website, but yeah, if you look for the spouse visa, exemption from spouse visa benefits, so there is a list of benefits: personal independence payment, disability living allowance, etc., etc. There are about 8 10 of them. If you get any of those, only then you would be exempt from meeting the financial requirement. Other than that, just by universal credit, you may not be able to sponsor your wife partner. If you are planning to remarry, as you said, you will not be able to sponsor being on universal credit unless you get any of those special benefits. Other than that, you may have to meet the financial requirement. So I have two dependents in the UK. So if you have two dependents, most probably they should be either settled or be British, most probably. That's what I'm assuming because they are with you now. So I don't think the financial requirement would matter. The calculation of the financial requirement will not change, but you may have to earn that 18,600 unless you get any of those other benefits. Next question. So whether I need to give yes or no in new entrant option. So your question is when you're filling up the certificate of sponsorship on the sponsor management system, there is a check mark whether you the employer. That's basically for the employer to select. I'm not sure whether you're an employer employee. So anyways, so whoever is a level 1 user, when you are filling up the course form on that SMS sponsor management system, there is a check mark to select new entrant, yes or no. So you are asking me whether you should select yes or no. So you select it as a yes only if you are taking the benefit of giving the applicant a lesser salary. So currently it is there. It will be ruled out after, I think they will take out the new entrant part after April. That's what is proposed as far as I remember. But as of now, only if you want to give the person a lesser salary, that is a new entrant salary, make sure you look at that, look at the immigration rules or take advice of a legal advisor. And if you are trying to pay a lesser salary to the employee, that is a new entrant salary, only then you have to select it as a yes, or else you have to just leave it blank. It's a check mark. I think it's a yes or no. So Arun Kumar question: my wife's care from domiciliary care not giving contracted hours to her, will it affect ILR application after 5 years or the salary amount can be made up in the later part of the year? I'm not sure what you mean by making up the salary amount, but then yeah, at this point, Home Office. So I'll just tell you as per the rules as of today. In future, I'm pretty sure Home Office is going to come up with something that they may check that the skilled worker is paid throughout the 5 year period or at least for the last one period. I don't know. It may happen in future because they do have access to HMRC systems. They can just run the applicant's national insurance number and find out whether all the salaries have been paid throughout the period. So yeah, if your employer is not giving the contracted hours, maybe you should think of switching the employer. That's the only option I can tell you. I'm an immigration lawyer. I cannot advise you on any other things on the employment law aspect and all. Maybe you may have to speak to an employment lawyer and all of that, whatever your contracts of employment were with your employer. But then your questions to be specifically to answer, will it affect your ILR? At this point, if you file an IRR application today, the only thing Home Office asks is three things: your latest payslip, which is issued within 31 calendar days from today, that payslip paid, that payment paid into a bank account, showing the bank statement showing that payment made, payslip, corresponding bank statement with the payment, and a letter from employer confirming that, mainly confirming that you are still required for the employment in question for the foreseeable future. These are the three main requirements as of today. Till today, whatever applications we are doing, even last week, whatever I filed, that is the only requirement in the immigration rules and on the form. Whatever else, that is just ancillary, all other things. So, but at a later stage, when your wife comes to ILR, I'm still answering Arun Kumar your question. I don't know what the rules will be. If the rules change and they try to see the whole 5 years and all, I'm not sure. I cannot predict anything. But those are the rules as of today. Next question: do you have any vacancy in the UK? Sorry, we are immigration lawyers. We don't provide jobs. We don't provide sponsorship. So, next question: whether I need to give yes and no. Raj, no, my course end date is 31st of May 2024. I'm doing my dissertation. I have to submit on 24th of May and I have less visa in the month of March. If my job start date will be after my course completion date, which will be 1st of June. Yes, of threshold will impact me. Okay, so the question is, it's two part. First is, as of today, whatever the rules are, yes, from your question. So the question is, course end date is 31st of May, whatever your course you will provide all your dissertations and all. Can you apply? For my purposes, I only care what is the course end date, which is 31st of May. Can you apply for a skilled worker visa in March? Yes, with a start date of that employment as 1st of June, which is after the course end date. Yes, immigration rules do allow you. I know someone in the last live had put a question stating that the person has applied in a very similar situation. However, Home Office has written back to them asking for proof of course completion. So I'm not sure why that is the case. In that case, you should engage immigration lawyers and get it sorted, because the rules do allow you to make an application before your course is completed with a work start date of after your course completion. So if your course completion is on 31st of May, and your job start date is 1st of June, you can apply in the month of March, 2 months before the course completion. That is perfectly fine because your course will be valid for 3 months. Yes, you can apply. And will the new immigration rules of threshold will impact me? That will really depend on when the certificate of sponsorship is issued, date of application. The rules have not come into play, so I don't know how they will apply, whether they will ask it from the date of application, from the allocation of the certificate. We have to wait and watch. I cannot advise on the new rules, they have not been published yet. But as of today, yes, you can do it, whatever the rules are today. Okay, live questions. Senthuram, do skilled worker visa dependent also have to pay NHS surcharge? Yes, dependents also have to pay NHS surcharge. Dependents of skilled workers also have to pay NHS surcharge. Okay, thank you, Arun Kumar. Meet Patel, what document check home office for 20-year long residence? Sorry, I cannot go over list of documents over here. Uh, Maybe seek an immigration lawyer's advice for that. This forum is only where I can answer the question in a minute's time. So usually that is what it is. But to briefly answer your question, if you are doing a 20-year long residence application, give them any proof of UK address that you have lived in the UK. I know you may not have it, that is what usually I've done many times. Applications I've explained home office, I've always got it. But then yeah, if you don't have much proof, explain, give any copies of your passport, anything that you can give to show that you were in the UK, a GP's letter, anything and everything to show that you were in the UK. The more evidence you give, the better it is. That's how I would put it. For a 20-year long residence, ILR, for overstayers, etc. So try to give as much proof as you can. But usually if you have all your passports, then it should sort out. If you just produce them all the passports, you entered the UK, at least you have that one. After that, you may not have a passport or whatever that is. I've also applied without passports and all. With 20-year long residence, it's a very open application. It really depends on the facts of the case. Some what you have, what you don't have, what are the facts, why you don't have things. So yeah, usually for 20-year long residence, definitely speak to an immigration lawyer. They will work it out, explain to home office whatever the issues are. Okay, next question. Dependents. Arun Kumar. Arun Kumar's question again, can a care worker work additionally for 20 hours without intimating home office in same occupation code or shortage occupation list? Yes, the answer is yes. In any skilled worker, not just a care worker, any skilled worker can work 20 hours additional on top of the current job, whichever job code they have. One, for example, they are given the skilled worker in a job code 1234, they can work in the same job code 1234 at the same level. So that is also, I think, I don't know how home office is going to check it, but that's what the rules say. If you're a manager, you should be a manager. If you are a subordinate, you should be a subordinate. That's what they say. Or in shortage occupation, any skilled worker can work up to 20 hours without informing anyone. You don't have to tell your employer also or to home office. That's your right. That's your personal right. Okay. Next, I have asked HSC this year, can I give IELTS? I'm not sure in what reference you are asking me, whether you should give IELTS and all. I'm sure I can only advise on immigration rules, UK immigration rules. I don't know why you want to give IELTS and all. So, next question is Ikra. Thanks for the video. I had a question about traveling after resignation during the 60-day period. If I have a Schengen visa, it is possible to travel abroad during the period, re-enter to move out permanently. Oh, once I leave the UK, I can re-enter. I can re-enter even if I'm seriously leave the period. Okay. Yeah, this is a common question that I've been asked. I will take the live question first. Let me complete this one. So when you end the job and you have that, you are in that curtailment period. If you have been, I don't think the job ending doesn't matter. So from the point you have been issued the curtailment notice by home office, if you are inside the UK, you have 60 days. So your BRPs or your permission is deemed to be ending 60 days from the date of issue of the notice. So if I'm issuing it today, it's 60 days from today. So, but then if you are already outside the UK, that thing doesn't apply to you. If the notice is issued today, you are out. There is no re-entry, there is no 60-day period. Secondly, the question that Ikra is asking is, if you resigned and within the 60-day period, can you leave the UK and come back to the UK? If a curtailment notice is issued by Home Office, then you may not be able to re-enter. So legally speaking, you cannot re-enter. If the immigration officer, they see on the system that a notice has been issued, you will not be allowed to come to the UK during that 60-day period. It's not to allow re-entry, it's just to change your immigration status from one application to another. If you want to make any other application, etc., that's the reason why it is given. Rakibul Hassan, I said, I am from Bangladesh. I have a question that is present. Parents' name spelled different from my passport and certificate. Will happen any problem? Uh, I'm not sure what the exact differences are, but usually in the visa application you will only use your passport details, whatever the name is, but you will have to prove maybe by an affidavit or something. If it is just one spelling mistake, it's a different thing. But if it's a completely different name, I'm pretty sure Home Office is not going to believe you that those are your certificates. So make sure whatever it is, speak to an immigration lawyer and see how much different it is. If it's just A or S missing here and there, that's a different issue. You can do an affidavit and explain it saying both the names are the same or something like that. But then if it's too much different, Home Office may not believe that those certificates are yours. That's what I can say. But speak to an immigration lawyer and get proper advice or and get your application filed through lawyers. Next question, Santuram. Sorry, I was wanting to ask if skilled worker visa dependent should pay immigration skills charge. No, immigration skills charge is only paid for the main applicant. It is not paid for anyone else, no dependents. Immigration skills charge. So I will explain you what ISC is. Immigration skills charge is 364 per year of visa for small employers, less than 50 employers. That is multiplied by the number of years. So we usually file 3-year visas, so it is 1092, 364 into 3. And that is only paid for the main applicant, not for dependents. Uh, that is like a fund the government has created to develop the local talent. So that fund is used towards the UK local apprenticeship schemes, teenage, whatever developments, training schemes, and all of that. That is where the money is used. Human account. Okay, hello sir. My question is TB test required for non-listed country for fiance. I don't know what you mean by non-listed country for fiance. Just tell me the country. I can most probably give you the answer also. So yeah. So Mukesh Raja, my GF is British. I reside in India, which is the reason visa to go to UK and get married and switch to dependent visa because she doesn't qualify under upcoming salary. 29,000. Yeah, if she doesn't qualify under the new future salary, then the best course of action would be before the changes come into play. If she's meeting the 18,600 salary requirement, you should file. One option would be she comes to India, wherever you are, I think in India, she gets married to you, and then you apply for a spouse visa before the changes come into play, or you apply for the fiance visa now. She should meet at least the 18,600 salary. Only then you can apply either of the cases. Then come to the UK, get married, and then apply for the spouse visa. Okay, thank you, Rakibul. Santuram, thank you. Premium. I live in Kuwait. Applying for fiance visa. Do I need TB test? I am not sure. Let me check quickly. Just a minute. I don't think. Just there is an appendix T. Let me search. Just a minute. I have to see on my computer. I don't think you will need, but let me still check. So it is Kuwait, MNOPQRST, Kazakhstan. Yeah, if you live in Kuwait, you don't need. In the last 6 months, you should be present in Kuwait. So that is the presumption I am doing. If you have lived there, then yeah, you would not need a TB test. But still, look at the guidance appendix T. That will explain you more. So the question, so the appendix T must. I'll try to answer. Must provide to me the same for 6 months, except the appendix. Yeah. So if for the last 6 months you have been living in Kuwait only, you would not need a TB test. So, for 6 months or more. This period or any length of within the 6 months before the date of application. Yeah. So in the last 6 months, if you have been living in Kuwait, you don't need a TB test. I have checked the immigration rules for you. Okay. Next question on the channel. Again, can I go back to the home country withdrawing my studies in the UK and come back as a sponsorship visa? Yes, you can do that. So this is a common question I have been asked. If you are a student studying, you can withdraw your studies. That's your decision. It's a personal decision. It's not necessary that you are abusing the system. You don't want to study, you don't want to study, or you will not have funds or money. That may be a different issue. But yeah, you can withdraw from your studies, go back to your home country, and then apply for a skilled worker sponsorship visa. So that is possible, provided everything is genuine. Okay, Shraja, do you provide visa services? If yes, how do I contact you? Okay, so go to the bio in the YouTube channel. There should be a website, visa-solutions.co.uk. You can fill up the contact form or call the office and someone will get back to you. So yeah, so that should be in the channel bio, whatever the YouTube calls it. Website is there and there should be a contact form, etc. So that's how you get in touch with us. I was traveling, but in no TB required countries like Dubai and Saudi. Do I still need TB test? Yeah, I don't think you would need a TB test, but this channel is not legal immigration advice. But from my experience, yes, that's how I understand it. If you have not gone to any TB country, we call it like that, TB country. So if you're not traveled to any of those countries, then in the last 6 months, then I think you should be fine. You would not need a TB test. But this is not legal immigration advice. This is just a guidance. I'm just trying to help here. Okay. So next question. I'm on a student visa and my course ends from May 24, 2024. My partner will apply for skilled worker visa on February and it's very possible to switch to student dependent student visa on March. So yeah, this is another common question. The answer is no, but then I will explain it. So you are a student, your course end date is May 24. Your partner is getting a skilled worker visa before that, sometime in February. You cannot switch before you complete the course of study. You won't be able to switch. You have to continue on your own. Your partner may have to go to skilled worker. And then once you complete your course, then you may be able to apply as a dependent. Okay. Okay, thank you. Premium account. Okay, so IHSP is increasing in January 24. Is the rule passed? The rule is not yet passed. Immigration surcharge. It will increase not before 31st of January. So that is for sure. I don't know how later after that, but it will not increase before 31st of January. So anyone planning to file, do file before then. How to meet UK spouse partner visa financial requirement. Started working in September. Okay, it will be 6 months. Qualifies. I don't fall under 1 or 2 years. So the question is about the financial requirement for a spouse visa. You started working, Mr. Gurung, September 23. So September, October, November, December, January, end of January, and February. February will be 6 months. From the year one. Yeah, so I'm assuming you are working as a salaried employee, not as self-employed. Self-employed is completely different game. So yes, if you have been working since September and if you have last 6 months of pay slips and proportionately your income is at least 18,600 annually, you may be able to apply after you get your 6 pay slips or after you complete your 6 months in employment. Yeah, so maybe you may have to wait till it in Feb it will be 6 months of pay. Yeah, correct. So maybe after you get your 6 months of pay, then you may be able to file. But I'm not sure whether you are self-employed or not. For self-employed, you need a full 12 months of financial requirement, taxes filed, paid, etc., etc. Next question. I'm currently doing job in a care home. They agreed to give me sponsorship visa. They are asking about my degree as per university status. Okay, my degree ending is 9th Feb, but by my result, of course, will come in March. When I get my degree in April, no solution because if dependent are going to close in April. Okay, can I give them this letter when degree ending? Okay, so yeah, whatever the dates are, you've given several dates. For the immigration rules purposes, if you want to switch to a skilled worker visa, your employer is willing to give you the sponsorship Your work start date should be after the end date of your course. So from what I get from all these dates, when my result will come, my degree ending date. So you are saying degree ending date. So I am assuming that is the course end date is 9th of Feb. So if your work start date is after 9th of Feb, then it should be fine. You can file the application now. We are already in 19th January. You can file it. About the dependent, so this is what the clarification I have from the fact sheet for dependents of those care worker visa holders. If the main applicant, so you are the main applicant and you already switch and you get the visa, and after that the rules change for the dependent, you will be able to bring your partner. It will not affect you. That's how always the immigration rules have changed, and that's what I read from the fact sheet. So you don't have to worry, you can switch your visa now. Even if the rules change, and let's say they change in April and you want to bring your family in June, your partner, you should be able to. That's what the home office fact sheet says. Should I get married? Okay, some live questions. Sir, I just was increasing in Jan 2024. Is the rule passed? No, I've answered that. I applied for a fiancé visa, submitted relationship evidence, but unsure how to prove my marriage intention is in the UK within 6 months. Should I book a venue? I don't think you are required to book a venue and all. I have done many applications without booking the venues and all. Sometimes they have given the notice, but notice you cannot give without the other party being in the UK. So in for mainly what whenever I remember I was in a meeting and I had asked this query to some of the managers in Sheffield that they that is a department that deals with appendix FM applications, and what the manager had clearly replied is that the main thing is we want to see that if you are applying, you are paying £1,500 for a fiancé visa, that itself is more than a commitment that we see that the person is in a genuine relationship. You may have to meet other things, but that is one is you're making the application. Second, you may give pictures that you have met, that is a requirement of the immigration rules. Other than that, yeah, whatever the plans are, if you all have already met, e-tickets, etc., any other proof that you can give, you can do it. But for the future, the wedding and all, you are not required to produce any substantial, that nothing is there in the immigration rules. You only have to show that your relationship is genuine. You can show it however you want to: WhatsApp chats, e-tickets of meeting each other, family meeting, photographs, anything and everything. That is the relationship side. But as per the immigration rules, there is nothing in the immigration rules that you have to book a wedding venue or spend a lot of money on your future marriage, which is dependent on the visa. So you don't have to book a venue. Immigration rules don't require it. But yes, if it is possible for you, the more evidence you give, the better it is. But the rules don't require you to do that. So next question. Okay, next question. Should I get married? I'm pursuing my bachelor's here because of lack of attendance university withdrawal my application. Okay, my boyfriend is on work visa. Oh, if we get married, can we dependent? Okay, so the question is about university has withdrawn your application, so you are no longer a student. You were a student, but you are no longer a student for whatever reason, attendance, etc. Your boyfriend is on a skilled worker visa. So if you get married, can I be dependent? You can get married, I think, if you have a valid visa in the UK. Even if you don't, you can get married. But the part of can you be dependent, you will have to go outside the UK, make an entry clearance application. Because you did not complete your course of study, you cannot switch from being a student to a dependent of a skilled worker. You have to go outside to your home country, apply for an entry clearance application as a dependent of your husband. Next question, Rakibul, is super shop visa considered skilled worker visa? I don't know what is a super shop visa. I am sorry. To the best of my knowledge, there is no such name in the UK immigration rules. Can we enter and exit the country on the same fiancé visa once granted? Fiancé visa is a multiple entry visa. I am sure, yes. Many of my clients have done that. But then, yes, you can. Technically, it is a multiple entry. That's what I have seen from past experience. But I'm just trying to help you. This is the guidance, not immigration advice. Speak to an immigration lawyer, get proper paid advice. But yes, that's what my knowledge is about it. It is a multiple entry visa. What is update regarding spouse visa income threshold? It's rule passed or not? The rule is not yet passed. It's still going to happen sometime in April. That's what Home Office say. The first point it is going to go up is to 29,000 in April. That's what has been proposed in the fact sheet. Rules have not been published, drafts have not been made yet. It's noisy over there, okay. Yeah, sorry. What about the residents who live in Ireland? So, yeah, I think this is the question regarding that. Yeah, this is a common question that I'm getting asked by visa nationals. So, for the UK purposes, there are two types of nationalities. One is a visa national, like India, Pakistan, China, etc., who need a visa to come to the UK, and there are non-visa nationals like USA, Australia, etc., etc. So, they don't need a visa to come to the UK. The ETA scheme, Electronic Travel Authorization, is only for non-visa nationals, someone who is American, Australian, etc. So I know many visa nationals are asking me all these questions. If we live in Ireland, what happens? It doesn't apply to you. The normal visit visa rules as they apply now will continue to apply. Whether you are a Pakistani, you are an Indian, you are a Chinese, whoever is a visa national, ETA doesn't apply to you. So I know people are asking Ireland, stamp 4, whatever they have, it depends on your passport, not what visa have you have in Ireland. So that Ireland stamp 4 doesn't matter for the ETA. The ETA is only for non-visa nationals. Okay, next question. What is update regarding sponsoring? Okay, that is done. I'm on PSW, which is valid until August 24. And apply for new entrant visa as I'm 22. Okay, so the new entrant thing. There is no such visa as an individual applicant can apply for a new entrant visa. There is no such visa. Let me clarify this. I know people are asking this. The new entrant is just a category in the certificate of sponsorship when it is a part of the skilled worker visa. Whenever a cost is assigned to a person, for example, let's say a normal salary is, I'm just taking an example, 27,000 for any XYZ job, and a new entrant who is new in the field, the employer can pay a lesser salary. Let's take an example and don't quote numbers. So instead of 27,000, they may be able to pay them 26,500. I'm just taking an example, something. So that is the only difference. When the employer wants to give a lesser salary to someone who is new in the industry, they can do that. They have to check mark that the applicant is a new entrant in that certificate of sponsorship, and they have to issue the certificate of sponsorship to the applicant. So individuals cannot apply. I know you are on PSW and you want to apply, you cannot apply for a new entrant visa. New entrant is just a category in the certificate of sponsorship where the employer can pay a lesser salary by selecting that option. That's it. Okay, next. Tahir Latif, hello sir. Why can't I find the priority service option when submitting my UK visa application? Visa application. Yeah, first is your category should be eligible. I think you may have already checked that. But then, yeah, if Home Office is turning it on and off, so if you don't see it there, they don't have it. You may have to try it every day or whatever that is. But then, yeah, Home Office is turning the priority on and off. So if they don't have the staff to deliver, they are not going to take your money and then just take £1,000 from you and then don't not deliver it in 24 hours or 5 days for priority service. So you may have to keep on checking if your category of visa has it eligible, that it is eligible for priority service. So yes, sometimes you may not see those priority services, or rather many times I don't see those priority services available. So Swami, it has been more than 3 weeks since I applied for defined costs. How long does it take to get this? Is priority service available for defined costs? For DCOS, there is no priority service. Usually, Home Office should decide within 2 weeks. I have got several courses in the last week in about 3 4 days also. I remember. Worst case scenario, 2 weeks. 2 weeks is on a higher end. You may have to follow up with the business help desk, etc. So Tahir, what VFS has the option for the priority service. Should I choose that? I don't know which visa you are applying for. Please clarify, Tahir. What is the visa you are applying for? Okay. Thanks for the support question. With 10 and 5-year road, if someone came on a spouse visa in 2015 and the 5-year road extension dependent on 2.5 years extension reject on financial ground to change payment road. Okay. Okay, the question is about so spouse visa, someone who is on a 5 year route, then continued, so got 5 year route in 2015, extension, and then at the ILR point, they were switched to 10 year route. So the earliest point to get would be you towards a 10 year route to settlement, you can count both 5 and 10. So if the time that you spent, the 5 years that you spent on the 5 year route and the next 5 years, so you at the point of ILR you were moved to 10 year route, so you may complete a total of 10 years from the first point when you got the spouse visa. So it's total 10 years from the first time you got onto the 5 year route. First time spouse visa, doesn't matter. So in your case, I think you completed 5 years on the 5 year route, then you were switched to 10 year route. So 5 years on the 5 year route and 5 years on the 10 year route. That's how you will complete the earliest 10 years. So for fiance visa, we will get priority. Yes, you should be able to pay. So, Tahir, if you're applying for a fiance visa, you should be able to get the priority service with the VFS. You may not get it on the gov.uk page, the application form page. When you go to the VFS website, there you should select priority, pay £500 extra, if I'm not wrong. Yes, 500 is for a priority for the fiance visa, and you can get that with the VFS. That is possible. So, student visa. Is it possible to switch my student visa to skill dependent visa? Continue my studies. Yeah, so this is another question, similar question. You are a student and you want to switch to become a dependent of a skilled worker, and you have not completed your studies. You cannot switch inside the UK. You have to do an entry clearance. So, Khadija, you are a student but you have not completed your studies. If you want to become a dependent of a skilled worker, you have to make an entry clearance application outside UK, preferably from your home country. Gene. Next question. Live for spouse visa, can I use the online version of the title register from the HM registry to prove ownership of the property or the official copy by post? You can use the downloaded copy. I know that you pay £2, £3 or £5, and from that HM land registry, that should be sufficient for the spouse visa or fiance visa. The downloaded copy is fine. You don't need it in the post. Uh, can a failed student we switch to a skilled worker visa? Apply for a tier for dependents on a 5 visa is going. It's fine. Yeah, so the question is your wife's visa is a, I'm assuming it's a tier 4 visa which is expiring in May 24. Can you join as a dependent and apply for a tier 4 dependent visa? I'm not sure whether you are inside the UK, whether you are eligible to switch or not, but if you are making an entry clearance application and your question is you just have 4 months left on the main applicant's visa, May 2024, the main applicant's visa is expiring, you can apply anytime before the expiry of that visa. It doesn't matter. So you can apply now, provided you are eligible. If you are in the UK, you are eligible to switch. If you're outside UK, you can apply anytime. Next question. If the home office needs more documents, will they reject the visa or request additional submissions? It depends on if it is specified evidence you missed. For example, if they've said 6 months of pay slips and you are not given a pay slip, they may not ask it because it's specified evidence. They may reject the application upfront. So if it's a specified evidence, they usually don't ask for it. That's what I've seen. So usually maybe file it through lawyers, get it checked by lawyers, do something if you want to make sure that all the documents are in place, etc. With the spouse visa, it's very different. Some caseworkers very rarely they do exercise discretion. I've seen, but then I have seen many applications where they have rejected for one of the specified evidence that they call it. So it's not necessary that they may write back to you. They may also refuse it. Do online PDF bank statements work for fiancé visa or we need the stamp one? The immigration rules for bank statements still say that you need a physical bank statement, stamped, etc., and all of that. But from practice, we have been giving online bank statements, but they cannot be transaction statements. They cannot be just, you cannot just do a start date and end date and run it. They have to be those ones which are saved by the bank. Usually all the banks in the UK, they save every month the whole month's bank statement. It has your name and address on the top. It's as good as a physical statement. You can use that one. That's what we have been using, and it has been fine. So yeah, but the immigration rules still say, this is what I will put it, the immigration rules have not been changed. They still say the same thing. It still says physical. Even I have read it last week. We've told Home Office, but still they have not changed. In practice, they do accept those downloaded PDFs. It has to be a full PDF with your name and address on it. Transaction statements are not accepted to the best of my knowledge. Yeah, I've tried that. Yeah. Okay, all the questions on the channel. Okay, let me see. Last one that I have. After that, any live questions, and then I will end it. So, hello sir, I am currently in the UK. I want to apply for visa, but I'm no longer work anymore. Just taking English class. What type of visa can I apply? Please let me know. Sorry, I really don't know what is your category. So, I'm currently in the UK. I want to apply for visa. So, I think you are no longer working with your employer, I think, and you are taking English class. I really cannot advise you what visa you should apply. Speak to an immigration lawyer, take a proper advice on your case, give them all the facts and see what is possible, what is not. But just to help you, unless you have any human rights basis, you have a child in the UK, you have a partner, husband, wife, whatever, without that, it may be difficult. So I don't know what is whether you have a valid leave now or not, but speak to an immigration lawyer, that would be better. Yeah, so if visa get rejected, do I get my refund? Which visa are you talking about? I think you were talking about fiance visa. If your fiance visa gets rejected, you don't get a refund. It's about 1500 something pounds. Uh, you don't get a refund. You will lose that money. Okay. No questions on the channel. I've answered everything. No questions live. So I will end this live now, and most probably I'll try to do it next week sometime. I've been very busy this week, so yeah, thank you very much for joining. All the questions you can keep on asking the questions on the channel with under any videos. Whenever I do these lives, I will answer them. Usually, I try to do it at least once a week. I paid 1920 for fiance visa. Why? Yeah, I think it should be. You may have paid in dollars or something. So I don't know what is the fees as of today. It may be in dollars. It may not be in pounds. Most probably, that's what I'm thinking. But in GBP, what is the fees? Let me see. So in GBP, the fees is, yeah, let's say, within UK, outside UK. Yeah, so sorry, my mistake. It is increased, so I forgot it was the previous fees. Now in GBP, the fees is 1,846. That is the fiance visa fees. My mistake. It changed in on 4th of October. So the fiance visa fees is 1,846 pounds. That's what you pay to the UK government, and you would lose that. Yeah, 1,846. That is the correct fees. I'm not sure what application you filed, but for fiance visa, 1,846. I'm looking at my own notes here. Yes. So there is a live question. Let me try to take that. How many months of not work can affect you while under a skilled worker visa or get ILR? You are inside the country, you are not working, and you are on a 3-year route. Can you also renew it? Okay, so first I will answer the easy part, the last part. If you are trying to renew a 3-year skilled worker visa and you're not working, it may be possible. Usually, preferably do it through a lawyer or something. The Home Office does not ask. I have not seen that. Whenever I have filed applications, they have not asked for latest payslip or a latest bank statement to extend a skilled worker visa. But I have always worked with reputed sponsors. We are managing the sponsor license. Everything is on top notch. Everything is perfect compliance. But I'm not sure if the compliance of your previous employer or the new employer is a bit sticky or whatever that is. You may be asked questions. You may be they may try to run some things on your record and see whether you are really working. To get ILR, as of today, I can only tell you what the rules are today. You need the latest payslip issued within the last 28 days, that payslip's payment being made in your bank account, bank statement showing that, and a letter from employer saying that you are required for the foreseeable future for that employment. That is the main thing. That's what you need, Emmanuel. How many months of not working? Okay, so you pasted the same question again. So I've answered it. Yes, you can extend. The form doesn't require you, but the caseworker may ask for anything. Uh, we have never been asked whenever I have done applications, but when you are extending, when you are from 3 years, you are getting further 2 years or whatever you are doing. But if you are applying for ILR, you do need the payslip, you need a bank statement showing that payment of the latest pay and a letter from employer. To I grant the visa, how more money is there to pay for next steps. For next steps, so if you get a fiancé visa, you come to the UK, you will get the visa for 6 months. It will be multiple entry, you can come in and out. That's how I understand. And within those 6 months, you need to get married, then apply for a spouse visa. The spouse visa cost, I will tell you in GBP. You will apply that inside the UK. Within UK, 1258, 1258 is the visa fees. Current immigration health surcharge is 1560, 1560. That's what you will pay. It will increase after 31st of Jan, I think. But then, yeah, that is the 1035 into 2.5. That's what the multiple should be. So current fees is 1258, spouse visa fees, 1560 NHS surcharge, and that NHS surcharge will increase to 1035 per year of visa multiplied by, let me do the calculations, 1035 into 2.5. 2587 will be the immigration surcharge once it increases. So Emmanuel, if you're not working throughout the 5 years but have the last 28 days payment of salary and payslip, you will get ILR. That is what is the case as of today. It will change in future, I can guarantee you that. There is a lot of abuse in the system. Home Office is not happy with all these frauds happening. People selling these visas. I have made several videos not to buy these visas, skilled worker visas. It's a lot of fraud. Home Office has just told us they are going to come up with some weird system. I know that they will come up with something. But in future, I don't think they will just take that 28 days a payslip in the last 31 calendar months. But as of today, that is the case. You just give that. Sir, within the UK, can a person shift from student visa to skilled worker visa? No. No. Then is there any law enforced? So a student can switch to a skilled work visa provided the course is completed. So either you apply after your course completion, or if you apply before the course is completed, your work start date should be after. So let's say your course end date is 31st of January, your work start date should be from 1st February or later. So it is possible once I'm in the UK resident. Yeah, so yes, you can shift from the student visa to skilled worker visa, but you need to complete your course and your work start date has to be after the course completion date. Uh, Once I'm in the UK resident, does my partner still need to work for me? Work for me? I don't know what you mean. Your partner needs to work for me. The sponsor, or however you are meeting the financial requirement, you still have to meet the financial requirement again, either by the same source or different source, whether you're using savings of 60 to 500 or whether you're showing your partner's income of 18,600, you will need to prove the financial requirement again at the spouse visa point. You prove it at the fiance visa point and then again at the spouse visa point, and you'll have to give the latest documents. So, for example, if it's by salary, last 6 months of pay slips, bank statements, letter from employer. Thank you, Emmanuel. Thank you, everyone. So I will be closing this live now. Thank you, anyone who joined, and no more live questions over here. Anything coming? Not yet. Okay, thank you very much. I'll be closing this. One last question. No matter I'm unemployed, 30 age. Can my mother sponsor proof of funds? My travel to UK visit visa. For a visitor visa, it's very difficult if your finances are not in place. If you are unemployed, you home office always looks for, you can try it, but it's unlikely because they will always look at your financial ties. Those are the main ones they look at, whether you have a job to go back, you have enough money to survive, you have reasons to go back. This is what home office thinks. I don't make the rules, but that's what I've seen from any refusals that I have reviewed. So if you have a job and your your mother can sponsor you for your spending and all, but they always check your credibility that you will leave the UK at the end of your stay. So yeah, Next question, what are the requirements of UK skilled worker visa? Yeah, for the requirements, usually always go have a proper consultation with an immigration lawyer. This forum is just to answer simple yes and no 1 minute questions. Sorry about that. Thank you very much. I have to end this live now.